Okay, so welcome to the Soul District Business Association Small Business Basics series, our ongoing business navigation and education series designed to help small businesses, small business owners with the challenges of operating successful and profitable businesses. Today's Business Basics series is hosted by the Soul District Business Association and sponsored by Sussman and Shank LLP and the Common Law Center. These events are produced in collaboration with Blossom Media, a firm who specializes in marketing to and for multicultural demographics. I'm Stephen Christian, and I'll be your moderator for this session and the sessions in the past and moving forward. Today's presentation will last approximately 45 to 60 minutes with time for public comment and discussion. Also, feel free to add your questions to the chat and we will make sure to get them addressed during the presentation as well. Today's topic is on estate planning. So estate planning 101. Making a plan for transferring your assets when you pass away is not particularly fun. It is vital. It's vitally important to help protect your property and build economic resilience for your family. Without an estate plan, your assets will pass under Oregon law and not necessarily to the people or in the order you'd like them to. The Estate Planning 101 webinar gives an overview of basic estate planning tools to help protect your assets to benefit your loved ones after you are gone, and to protect yourself in case of illness or injury prior to your passing. Simple legal tools can avoid an expensive public and conflict-producing process in the probate courts and provide you with the care you need throughout your life. Our expert presenter today is Ekua Hackman. Ekua is a fellow attorney with the the Commons Law Center, practicing in estate planning and probate. Born and raised in Stockton, California, Ekua received her bachelor's in sociology from Loyola Marymount University in Los Angeles, California in 2011. She realized she wanted to combine her desire to serve the community with the practice of law. So she attended Willamette University College of Law in Salem, Oregon, and graduated in 2015. Her hobbies include reading and watching fantasy and science fiction, baking, and avidly listening to music. So do me the honor and the favor of welcoming Ekua.
All right. Thank you very much, Stephen. So, thank you for coming. And before I get started, I'll ask that you mute yourself so I can time for questions. All right. Thank you very much. I'm glad you're interested about learning about the basics of estate planning. At the very least, I hope I can ease your minds about how to protect yourself and your family with the basic estate planning tools that I'm going to cover with you today. As Stephen said, my name is Ekua Hackman, and I work for the Commons Law Center as the lead attorney working on the Home Ownership Asset Preservation Program. This program provides free, and I repeat, free estate plans for residents who qualify, and participants usually qualify if they are homeowners who live in North and Northeast Portland and meet income requirements. Now, the purpose of the program is to combat gentrification and build intergenerational wealth, primarily in the Black and POC community. To qualify, you will contact the African American Alliance for Homeownership. And if you qualify for a free plan, they will let you know and forward you to me so we can work together. Now, if you don't qualify, you may still qualify for sliding scale services from our office at the Commons Law Center. All right, moving too fast, pardon me. Now, before we get started, I want to remind you that this is general legal information meant to educate, not legal advice. At this time, I'm not your lawyer, most of you, nor am I acting as your lawyer by providing this legal information. That being said, let's get into it. Oh, 1 second. All right. As we let you know before, the webinar is designed to educate with the basics of estate planning. We're going to talk about the current status of wealth in the United States, why estate planning matters, common reasons why people don't create an estate plan, and then give an overview of a few of the basic estate planning documents and their purpose. Now, as I'm covering these topics, a reminder that you can please feel free to submit your questions to the chat feature or take some notes to remind yourself for the end of the presentation. And we'll try our best to answer your questions at the end of the presentation. Now, it's probably no surprise to you that the wealth gap in this country has been steadily increasing with more money concentrated in fewer people. And it probably doesn't surprise you to know that communities of color are unequally impacted by this widening gap. And the pandemic has made this far, far worse. Here are some stats that I found. In 2016, the wealth of a white family was 7 times greater than that of a Black family, and 5 times greater than that of a Hispanic family. And homeownership accounts for about 25% of all that wealth. Homeownership is at the center of wealth accumulation for the American middle class, and this is especially true for communities of color. 54% of wealth in the Black community is tied to home equity. Now, since most of the community's wealth is attached to homes, it makes sense that those same people will be the most impacted by the loss of homes. Now, according to a study done by Portland State University and the Coalition of Communities of Color, Black family income in Multnomah County is less than half of that of white families. And the poverty rate among Black children is nearly 50% compared to 13% for white children, which makes no sense to me. I know how hard we work. Additionally, fewer than 1/3 of Black households own their homes, compared to about 60% of white households in Multnomah County. Black folks have experienced housing displacement and the loss of community as the historic Albina district has gentrified. Now let's take a good look at this figure. Over the last century, the Black community has lost nearly 3.8 million acres of land, valued at about $6 billion, in part due to people dying without a will and the state selling off and dividing that property. The state keeps the proceeds of those sales when there is no will and when the heirs of the person who passed away can't be found. And to make these numbers very real for you, I'm going to highlight a few important stories and the importance of estate planning, a few real world examples of Black families losing land. And I want to give credit to The Authentic Voice and ProPublica for collecting these stories. I'll begin with the Becketts. The Becketts lost a 335-acre farm in Jasper County, South Carolina that had been in their family since 1873. And another family, the Sanders, watched helplessly as a timber company acquired 300 acres in Pickens County, Alabama, that had been in their family since 1919. These families were stripped of their lands by a court procedure called partition. Now, partition was intended to help resolve land disputes, but it's being used to pry land from people who don't want to sell. And Black families are especially vulnerable to it. In the course of generations, heirs tend to move away and lose any connection to the land. If more family members die without wills, things can get very complicated within a few generations, with dozens of relatives owning the land in common. Land traders can buy off the interest of one heir, just one heir or speculator, no matter how small, their share can force the sale of an entire plot of land through the courts. Now, some land traders seek out such estates and buy small shares with the intention of forcing auctions. Family members rarely have enough money to compete, even when the highest bid is less than the market value of the land. Even when the process of partition works as intended, it contributes to the decline of Black-owned land, and the property nearly always ends up in the hands of white developers or corporations. Now, correcting the title to land and estate planning can prevent a great deal of this kind of stress. Estate planning can safeguard that wealth and those assets and ensure that it stays within the family. Just a few more stats and then I'll move on. The percentage of people with wills varies among different socioeconomic and racial groups. About 53% of white adults have wills, while only about 28% of non-white adults have wills. Even though proper estate planning can preserve intergenerational wealth, about 58% of adults ages 53 to 71 do not have a will. And only about 31% of people with a household income of less than 30K have a will, while 55% of people with an income above 75,000 do, which makes sense. White families are 5 times more likely to inherit from deceased loved ones than Black families are. As it suggests, the Black community does not benefit from inherited wealth as often as other groups. Now, as we will learn, estate planning facilitates the transfer of wealth from one generation to the next by passing on money, personal property, and homes. Now, these facts are troubling and they bug me quite a bit. We need to fix this in any way we can. Targeted estate planning for the community is one critical step towards fixing this problem. Part of my goal is to make estate planning understandable and accessible. I want you to know that these tools are within your reach and should be a priority. So with that background information in mind, let's talk about estate planning and why it's important for us, especially. Estate planning can accomplish many goals. It can streamline the property from one generation to the next. Estate planning can allow you to pass down assets unequally among children if you wish, or pass them directly to grandchildren, or make gifts or to other important people, organizations, or churches in your life. Proper planning also ensures economic assets stay within the community. You can make sure your children and grandchildren don't have to start from scratch. Not only does planning give the immediate beneficiary the benefit of the money inherited, but it also prevents them from being sold off and forced to move out of family homes. Now picture the entrepreneur with the idea to start a business, but without the money to get started. Black entrepreneurship has skyrocketed during this pandemic. We've been forced to get really creative. Even a $10,000 life insurance policy could have a huge impact on making a step in the right direction and achieving that dream. Now, not having a plan in place can lead to dealing with unexpected parties and costs, and they always pop up when you can least afford it, along with no control over who inherits or where your money goes after you pass on. And families with modest means can least afford the consequences of dying without an estate plan. Now, even knowing the importance of estate planning, many people still don't create one. Why not? The common reasons for not creating an estate plan include assumptions that the assets will automatically be passed down after death, assuming that someone will inherit a piece of property just because they are a family member or currently live in grandma's house, distrust of the legal system, which is incredibly fair and earned, inability to afford legal services to create an estate plan, also very fair, makes sense. The belief that estate planning is only for wealthy people who have lots of money or items to pass on, common misconception. And the biggest reason people don't create an estate plan is procrastination. It's easy to think that you will get to it someday or that you aren't elderly, so it's not important to worry about right now. But being prepared, regardless of your stage in life, is essential to ensuring your wishes are carried out and your family is cared for when you pass away. Now that you've learned a little bit about the current status of wealth, why estate planning is important, and why many people don't create estate plans, you might be wondering, well, what exactly is estate planning? So estates are not just for rich folks. I believe the word estate leads people to believe that tremendous wealth is required to create an estate plan. An estate is just the property you own, individually or jointly with another person like your spouse. Your estate includes real estate, vehicles, bank accounts, retirement accounts, jewelry, and even pets. An estate plan is a set of legal documents that describes what you want to happen to that property after you die, who you want to be in charge of making sure those wishes are carried out, and what happens if you become unable to take care of yourself while you are alive. Now, there are a handful of basic estate planning tools that can help you accomplish your planning goals. They include your last will and testament, a revocable living trust, a power of attorney, and a healthcare advance directive. Those are the documents I'm going to cover with you today. Now, the first document we're going to talk about is a will. A will is a legal document that only becomes effective when someone dies. It explains who will be in charge of your estate how your final expenses will be paid, and who will inherit your assets after death. Now, earlier we talked about how few people actually create estate plans. So why is having a will important? Above all, wills give you control over what happens when you die. Now, when a person dies without a will, their property will pass by organ law. For example, if you die without a will and you have a spouse and kids from a previous relationship, the assets would be split between that spouse and those kids from that previous relationship. Now, a scenario like that is an example of how these laws may or may not mirror how you would like your property to be distributed, which is usually why it's better to have a will. Wills can serve a couple more important purposes. As a reminder, I'm going to reiterate that a will allows you to leave your property to whomever you want in the way you want when you pass away. You also get to name a guardian to care for any minor children that you cared for when you pass away. Even if you don't have many assets to plan for, naming a guardian is one of the most important reasons you would still want to have a will. You want to make sure your kids are cared for by the people you want them to be cared for. As mentioned in the previous slide, with a will, you can name someone to be in charge of your will, and they're called a personal representative. And they're also known as an executor or administrator. The personal representative is responsible for carrying out your last wishes stated in your will and making sure that your final affairs are taken care of. You may wish to name an alternate personal representative in case the first person you name is unable to serve. Now, if you don't name an alternate, the courts will do it for you. This is an important role, so you should talk about this with your loved ones and make sure whomever you appoint is willing and able to carry your wishes out. A common question that I receive is, if you have a will, can you avoid probate? Short answer is no. Having a will does not necessarily help you avoid probate, but having a will can reduce the cost of probate and the burden to your friends and family. Whether your property needs to go through a long and complicated probate is determined by the value of the property, not by the value of the property and how that property is titled, not by whether you have a will. Now let's briefly talk about probate, because not everyone understands what that is. Probate is a formal court process that serves three main purposes. It notifies potential creditors and heirs of your death. It confirms that your debts and final expenses are paid, and then it transfers title or ownership of your assets to the next generation, next of kin. Leaving an estate plan can help avoid the process of the court having to locate your heirs, also reducing the time and cost of probate. Anyone who has been through probate knows that it is a huge pain in the butt. The process in Oregon can take about 8 months to a couple years, depending on how complicated your estate is. A 0 out of 10 would not recommend. Filing fee by itself can cost about $591 plus the cost of an hourly attorney. And the average person couldn't afford that. I'd say if you can at all avoid probate, take the opportunity to do that. Now, a long and complicated probate is not always necessary. Now, if the deceased person owned a bank account or property with another person, the surviving co-owner will often just own that property automatically. It just bypasses the need for probate altogether. If a person dies leaving very few assets, such as personal belongings or household goods, these items can be distributed among the rightful beneficiaries without the supervision of the court. That's what you want. But sometimes probate is needed to clear title to land or bank accounts that were held in the name of the deceased person alone, and put title to these assets in the names of the rightful beneficiaries. Sometimes probate is needed to collect debts owed to the deceased person or to settle a dispute between people who claim they're entitled to assets of the deceased person. Or, last but not least, sometimes probate is needed to resolve any disputes about the validity of the deceased person's will. For example, if grandma had a touch of dementia toward the end of her life, and you noticed that a distant cousin suddenly started visiting her prior to her passing away, and then you find that grandma created a whole new will that left everything to this random cousin, even though grandma's original will left everything to her 3 kids, you might not need to resolve that in probate court because that's a mess. Now, another way to protect and maintain control over your assets is through a revocable living trust. Trust can be kind of complicated, so bear with me and just remember you don't have to memorize any of this. This is just some basic information. A trust is like a bucket that you put all of your assets into during your lifetime. The trust or the bucket becomes the owner of those assets. Now, with a trust, probate is typically not required, so long as all those assets are properly titled as owned by the trust. I'm going to repeat that for you. With a trust, probate is typically not required, so long as all assets are properly titled as owned by the trust. You remain in control of those assets during your lifetime, but when you become incapacitated or pass away, a third party known as the successor trustee automatically takes over managing the trust and making assets based on the terms of the trust. The successor trustee is a person that you choose. You have control over who takes over and manages your property for you. Here, you can also name an alternate successor trustee in case the first person is unable to serve. A trust is also helpful when your beneficiaries are minors or at risk of misusing funds, such as to support an addiction. You can control how the money is distributed. For instance, you can say, my daughter will not be receiving any of these funds unless she goes to rehab, and we will cover the cost of rehab, or not. But that's one way you can control the way the money is managed. Having a revocable living trust can also help with incapacity planning, like a power of attorney or an advance directive, which I'm going to discuss in greater detail now. Now, the next document that can help you achieve your estate planning goals is a power of attorney. Just as a background, there's two forms of power of attorney: a financial power of attorney and a medical power of attorney. The first one I'm going to discuss is the financial power of attorney. The financial power of attorney is a planning tool that protects your assets while you are alive, but unable to manage your financial matters due to serious illness, disability, or injury. Now, setting up this document is helpful when you are alive, but unable to manage your bills or understand your finances. I'm going to use the car accident scenario a lot. So you get into a car accident and you are down for the count, injured, unable to manage anything for about a month or maybe longer, depending on how severe the injury is. This is going to be super helpful because it allows you to appoint someone to handle your money for you. Now, a power of attorney has two parties, a principal and an agent. The principal is you, the person creating the power of attorney, and appointing someone you trust with the power to manage your money and your property. It's a very powerful document. The agent is someone you choose to manage your assets while you are incapacitated. Now, the agent can be anyone over the age of 18 who isn't incapacitated themselves. As I said before, this is a very powerful document, so you'd want to talk to the agent beforehand to ensure that they are willing and able to act as your agent and that they understand your instructions and your priorities in case the need to use the power of attorney arises. It's also a good idea to choose somebody who is good with money as your agent. If this person has a history of being careless or reckless with money, maybe take a little extra time to consider someone else in this role. You don't want somebody to rob you blind, first and foremost. You may wish to name an alternate alternate individual in case the first person that you name is unable to serve. Now, the financial power of attorney can be drafted to kick in the moment the document is signed, or it can be drafted to take effect when you are officially declared incapacitated by a doctor. But most attorneys recommend you draft it to kick in the moment you sign it, just because having to deal with going through the process of being declared incapacitated can delay the document being used. And sometimes those delays can be just very unhelpful to you. Now, at that point, the person you appoint to be your agent steps into your shoes and acts on your behalf and for your benefit. The agent's powers include financial situations such as paying bills, selling property as needed to pay for your care if you're needing long-term care, filing taxes, and any other instructions you've listed. Now, your agent's authority can be as limited or as broad as you need it to be. This includes limiting authority to one bank account, or giving the agent the authority to manage your finances temporarily while you're out of the country. Powers of attorney are flexible, so remember that it's completely up to you. Your agent's authority over your assets will end when you revoke the power in writing or upon your death. So what happens if you don't have a power of attorney? If you are unable to manage your financial affairs and don't have a power of attorney set up, your family may have to go to court to appoint someone to manage your assets. This person is commonly called a conservator. A conservator plays the exact same role as an agent, but the conservator is someone that's appointed by the court instead of by you. It'll basically be a stranger managing your money. If you end up needing a conservator, your family will have to hire a lawyer, go to court, and deal with possible delays and invasions of privacy concerns. This process can be confusing, time-consuming, and incredibly expensive. So it's incredibly worthwhile to invest in putting a plan in place ahead of time. Even if you never end up needing it, it saves you a ton of money to have a power of attorney in place. Many banks in some states have their own power of attorney documents available for free. Bottom line is, having a power of attorney can help avoid the need for conservatorship. Now, as we switch to talking about the Healthcare Advance Directive, or the medical power of attorney, I wanted to share a few important statistics with you. According to the American Bar Association, Black elders are less likely to receive hospice or other comfort care at the end of life and are less likely to have their pain effectively managed. Black elders also tend to have the lowest rates of advanced care planning nationwide. This includes planning for elderly care and end-of-life decisions. This is terrifying. Explanations for the low rates of advanced care planning include mistrust of doctors and the healthcare system, very valid and very real, the religious beliefs, leaving it up to God basically, which yes, but also you want to take care of yourself. Unwillingness to acknowledge a terminal diagnosis, greater desire for life-sustaining treatment, low health literacy, basically the ability to read and understand healthcare information, and doubts about the effectiveness of advanced care planning. How is this going to serve me? With that information in mind, let's take a brief look at the Advanced Directive. The Advanced Directive is the term used in Oregon specifically for the legal document that creates a medical power of attorney. An Advanced Directive allows you to make it clear what you would like to happen with your medical care if you become so sick that you're not able to care for yourself. This document ensures that your medical needs and care are guided by your wishes. In the Advanced Directive, you appoint someone called a healthcare representative who will make decisions regarding your medical care if you are incapacitated. Your healthcare representative can also advocate for you in a medical situation. For that reason, you should select someone who is willing to serve in that role and who you trust to follow your wishes. In this case, you have the ability to name alternates in case the first person that you choose is not able to serve. When choosing a healthcare representative, there are a few important factors to consider. First, is the person playing this role assertive? Keep in mind that your agent may have to fight to assert your wishes in the face of a stubborn medical establishment and against the wishes of family members who may be driven by their own beliefs and interests rather than yours. If you foresee the possibility of a conflict in enforcing your wishes, be sure to choose an agent who is strong-willed and assertive. Second, does this person live close to you? While you don't necessarily have to name someone who lives in the same city or state as you do, location can be critical sometimes. If you have a long-term illness, your agent may be called upon to spend weeks or even months nearby, making sure medical personnel abide by your wishes for healthcare. And third, will the person you name also be your financial agent? If you make a power of attorney, you might consider naming the same person as both your agent for healthcare and your agent for finances. If you feel that you must name different people, because not everyone's good at both healthcare and finances, be sure to name agents who get along well and can work well together. You wouldn't, for example, want your agent for finances to interfere with your healthcare wishes by stalling or resisting payment of medical or insurance bills, two things over which your agent for finances will most likely have control. Now, there are several medical decisions that are addressed by an advance directive, and they include resuscitation, mechanical ventilation, tube feeding, comfort or hospice care, organ and tissue donation, and donating your body for scientific reasons. You're also given the opportunity to include any religious preferences to help guide your care. Now, it's highly uncomfortable to talk about these things, but it's so important to have a conversation with your loved ones about what you want in case you're unable to communicate with your doctor. Most people will reach a point in life where they can no longer speak for themselves, where living longer lifespans than ever. No one can predict when unexpected medical situations will happen, and they can happen whether you're young or old. When this happens, doctors hope to provide the treatment that the patient wants, but sometimes your wishes aren't clear. With an advance directive, you can make it clear what your wishes are and potentially avoid a great deal of tension and conflict. After you have an advance directive, it's a good idea to give a copy to your doctors and to your healthcare representative. Because you might change or update your advance directive in the future, it's also a good idea to keep track of who receives a copy. Review your advanced care planning decisions from time to time because you might want to revise your preferences if your situation changes. For example, you might want to make adjustments if you receive a serious diagnosis, if you get married, separated, or divorced, if your spouse passes away, or if something happens to your healthcare representative. If your preferences change, you'll want to make sure your doctor, your healthcare representative, and your family know about them. Planning for the worst case scenario can be hard, but it is essential. Now, before we close, I wanted to mention a few other tools that can help you avoid probate and make sure your assets go where you want them to go. One way is joint ownership. It provides a fairly simple way of avoiding probate when the first owner dies. To avoid probate, you take title as joint owners with someone else. And when the first person passes away, the surviving joint owner would take the house. No court involvement is required. Another way is payable on death bank accounts. They offer another super easy way to keep money out of probate. All you need to do is fill out a payable on death form provided by your bank, where you name the person you want to inherit the money in your account at your death. Now, as long as you are alive, the person you name to inherit the money has no rights to your account. You can spend the money, name a different beneficiary, or close the account. At your death, the beneficiary just goes to the bank, shows proof of the death and of his or her identity, and collects the funds that are in the account. Probate court is not involved. Now, if you and your spouse have a joint account, when the first spouse passes away, the funds in the account will probably become the property of the surviving spouse. No probate. If you add a payable on death designation, it will only take effect when the second spouse passes away. The rules are very similar for a transfer on death account. You can leave stocks, brokerage accounts, or bonds without them having to pass through probate. This works like a payable on death account where you register your ownership and designate a beneficiary. Last but not least, talk about beneficiary designations like retirement or life insurance policies. As you know, when you open a retirement plan, such as an IRA or a 401k, the forms you fill out will ask you to name a beneficiary for the account. After you pass away, whatever funds are left in the account will not go through probate. The beneficiary you named can claim the money directly from the account. Now, if you are single, you are free to choose whomever you want as a beneficiary. If you're married, your spouse may have some rights to some or all of the money. Now, thank you so much for coming and learning with us about the basics of estate planning. If you are interested in seeing if you qualify for a free plan provided by the African American Alliance for Homeownership, provided by the Homeownership Asset Preservation Program, you're going to reach out to the African American Alliance for Homeownership at 503-595-3517. and you're going to reach out and ask to see if you qualify for the homeownership asset preservation program. I'll leave some time for questions.
Yeah, so does anyone have any questions about this?
Well, Ekua, I have a question, Stephen.
Yeah.
Okay, so how does, so you brought up a lot of good points. I don't know if you can go back to this slide, but it was the slide about why people don't, right, have an estate plan. Because there's all this assumptions that if you're living with a significant other, of course we live in a day, not everybody's married, right? So if you're living with a significant other or you know, cohabitating or whatever you're doing, the assumption is that you'll get that. But you're saying it's not necessarily the course. So how do you approach your partners to that this is an important thing to do? How would you how would you approach the beginnings of conversations with somebody important in your life about the need to do this if you're, you know, both sort of involved?
Yeah, I'm learning as I'm doing this work, I'm really learning there's no one approach for this. Every person is very different. I'm having different responses from many people to this presentation, to intake, to this whole process. It just really helps to know the person and what matters to them. You have to appeal to them and what matters to them. If they're a really practical person and they're very interested in not losing access to the life that you have built together, I'd say we need to put a plan in place, or else we could lose everything we built together. Even if you think you're entitled to it, because we aren't married, put a plan in place. That I think is the biggest argument to appeal to. If you're trying to be like extremely practical, they don't want to have to go through probate because, like I said, it's very costly for the average person. Minimum $600 filing fee, plus the cost of an hourly attorney. And as a young attorney, I don't cost much, but an attorney who is 5-10 years in will cost a lot more than me. Yeah. So
and outside the immediate family, does any family member, cousin, this or that, also have an opportunity to sort of make a claim?
Cousins, less likely unless you have no siblings, no children, no parents living. Only the next of kin goes spouse, children, grandchildren, and then parents if none of those people are living, and then you go on to aunts, uncles, because like it just there's an order of operations basically. There's a way.
Okay, gotcha. And did you say even like former spouse, if you hadn't remarried, former spouse gets...
Not former spouse, current spouse, and children from your previous relationship.
Oh, okay, gotcha. Okay.
Right,
thank you.
Of course.
Right.
I see a hand raised from John.
Yep.
Yeah, good morning, and thank you for the presentation that you give. I'm just curious, because when all this stuff is filed, does everything have to be in good standing? Say if a person created all these things and they have sort of, let's give an example. Suppose a person is in bankruptcy somehow and they die, right? And they're managing the bankruptcy, right? Say if a person files a chapter 13 and reorganizing their stuff. And in the midst of that chapter 13, even though he has one of those things or she has one of those things in place, how does that unpack itself?
I don't really deal in bankruptcy law, but my guess is that be paying off those debts and that next of kin might not be receiving much, if anything, is my guess. But like I said, I don't really deal in bankruptcy. We can talk about this later and I can definitely look up the answer for you.
Okay, and so might you assume though that nothing can be have any kind of hitches or glitches in it. It just needs to be a straightforward kind of a planning situation that you're talking about, and everything has to be sort of like free and clear, up to date, all of that kind of stuff. Because the reason why I'm asking this question is that even though a lot of us may not do the estate planning, a lot of us are encumbered also somehow. And
Right.
there's some reasons why they can't get to the estate planning.
Mhm.
So is there so am I to assume everything has to be pretty straightforward and free and clear?
Not necessarily. As I mentioned, there's a couple easier ways to make sure that money passes on, like the payable on death account, making sure that money, whatever's in the account, goes on to your next of kin or whoever you list as your beneficiary, or owning a house jointly if you own property, to make sure that that house goes directly to the surviving co-owner when you pass away. Those are some ways to prepare for passing away without dealing with an attorney, generally speaking. One of the more inexpensive ways of doing that. Same with the power of attorney and the advance directive. Power of attorneys provided by banks, sometimes provided by the state that you live in. But I would just caution you to read each line of that document carefully, because most people recommend you have an attorney when you do create a power of attorney, just because you don't know always what the effect of that document is going to be unless you read each line and understand what the impact is going to be. But advance directive, definitely you can do without any attorney's help. That form is available online, but most attorneys provide a more expansive more expansive advance directive, provide you with more options for your care so that you can specify what you want to happen to yourself and what your healthcare representative's instructions should be. Oops, sorry, my calendar went off. Yeah, there's a lot of ways of doing planning that don't involve a will, but I'll say this. If you don't qualify for the homeownership asset preservation program, look into maybe looking at the Commons Law Center. They provide sliding scale, lower cost ways of getting a will. I understand that the cost of legal services is a huge burden on the average person getting any sort of legal help, generally speaking, not even just an estate plan. I'm fully aware about 80% of the state of Oregon has unmet legal needs, generally speaking. Even with legal aid in existence, 80% of the state does not get the help that they need, legally speaking, which is atrocious, really. But I understand that any debts and encumbrances may be a hindrance to you getting what you need. But for the things that you can't afford, definitely try to put those in place. Maybe make sure the bank accounts are covered, making sure that your real estate is covered and someone's going to inherit it when you pass away. Life insurance, retirement, those things you can probably take care of on your own. I hope that partially answered your question. Am I missing anyone else?
I think that was it.
Okay.
With all of our questions.
All right. Well, thank you very much for coming, and I hope to see some of you through the asset preservation program, because the whole point of me having this job is to serve people in the community who want help with their plans, and I'm hoping to see some of you come through.
Yeah, definitely. Really appreciate all the information and just getting an introduction to it, because like you said, some of us may know or may be familiar with some of the terms and may not think that it applies to us, and just having some clarification and seeing how relevant it is to our lives, it's very valuable. And so me personally, I really appreciate it. I know others do as well, because this is how generational wealth is built, right? And
Yes.
it looks like when will there be another presentation? I would like to send this to some clients. So I'm not sure, is that may be for you. So do you know when you will be presenting again?
I'm going to stop sharing if that's okay for a second.
Oh yeah.
Okay. We are going to have more presentations, actually. Let me look at right now.
Well, and Stephen, this is going to live on our websites too.
Yeah,
So
yeah,
this can be shared. So
yeah.
Okay.
And I will share all the information to where this recording will be.
Okay. Because yeah, we have other presentations coming up through let's see. The next presentation is on Thursday, June 24th. Well, let me see. I think I had that wrong. You know what? It's okay. We'll get back to you about that because I'm looking through all my emails and it's becoming overwhelming right now. But there's going to be another presentation at the end of the month. Usually we have presentations on a monthly basis and we put flyers out. So I'm happy to distribute those so that you can see when the next one's upcoming.
Where can I find the information?
The African American Alliance for Homeownership website. We update,
Okay.
yeah, we update with current dates.
And Ekua, I know that there are other organizations. Markeisha, I know you represent an organization, so maybe Ekua could do one specifically for you and your clients.
Absolutely.
Right, Ekua?
Very happy to do presentations for other local organizations.
Okay, sounds good.
Awesome, awesome. Yep, making connections. That's what this is all about.
Yes.
I like it. I like it. And so we'll do the send off, the wrap up. Or Shirley, did you have something?
No, I just wanted to thank her for the presentation.
Of course, anytime, Ms. Miner.
Thank you.
Yeah.
Shirley, I have a question for you though, considering that, you know, you've been kind of involved in this as somebody who's gone through this. What did you find most valuable about what Ekua said today?
Well, yeah, I had partially been involved with it before. This time around, I'm learning a lot more. It's very hard going through this process if you don't know much about it. And initially, I had an attorney that didn't follow through on things, and I missed certain important dates. Now we're in line with these dates. I understand things better. I will know when someone's giving me, so to speak, a snow job. And I feel more comfortable that I will be passing assets and information on to the next two generations below me. Because that was another big fear was I have a condo that I've worked real hard at keeping all these years, and I didn't want to lose it. And in terms of going to meetings and interacting with other people that are Black, many of us have lost our family, homes, and legacy because we didn't understand what we needed to do. And my hope is in the now and in the future that I'll be in a position to explain some of the things I've learned and encourage people to take advantage of this particular law firm. That's what I want to do, is tell more people about it in hopes that if they see someone in the community or the neighborhood going through this, they'll feel more comfortable taking advantage of it.
Thank you.
Nice. Thank you. Thank you. And so with that, if you'd like to listen to this presentation again or past episodes of the Soul District Business Association Basics series, it'll be available on the Soul District Business Association website, which you can find at www.souldistrictbiz.org or on the YouTube channel at Flossom Media TV. And also, please follow the social media accounts for any of the updates on the small business opportunities in the area. And if you have any other questions or ideas for the series, please contact 503-841-5032. And I believe we'll have another presentation in the next couple of weeks. And again, thank you, Ekua, for giving us some wonderful knowledge. Yeah, really appreciate it. Really appreciate the information, and hopefully anyone that's watching or that participated in this is able to, apply this to their situation and their lives. Because that's just one little step after another is how we build how we build a legacy. And so these are the necessary steps to do that. And so yeah, really appreciate it. And that's it. I think we can wrap it up from there.
Okay. Thank you very
Thank
much.
you.
And, take care, everyone.
Thank you.